things like it comes through and I say like.
All right, we are on the record.
Okay, we're on the record. It's 12:05 on December 21st.
Seasonal log.
Season. And the Rent Adjustment Commission is called to order. Let's have a roll call, please.
Commissioner Lucas?
Here.
Commissioner Barton?
Here.
Commissioner Stoller?
Yes.
Commissioner Dollar?
Yes.
There are 4 commissioners and we do have quorum.
All right, item 1B, HCIDLA report.
Susan Gosden for the department, and in light of the very busy schedule, and then we'll also have a discussion for in item number 2, we will not be having a full HCIDLA report, but I must inform you of this very important news. We had on Tuesday our holiday party, in which there is included with the party is an ugly Christmas sweater contest. And it included a dance-off of sorts. And the winner was our own.
Do tell.
And the winner was our own Stephen Harrison.
You have video.
And that concludes.
It's been up on YouTube.
It should be on YouTube, yeah.
And that concludes the housing department's report.
I barely missed it.
Well, the sweater is on display if you care to look on your way in or out. Right,
But it
by the
wouldn't
cubicle.
look the same, just
Right.
Why are you wearing it?
So if you want to like an instant replay?
We're pushing this model too far. In the interest of
Yeah, we want to
time.
have a model. That's right.
'Tis the season.
Well, congratulations.
Awesome. Yeah.
Congratulations. It's quite an accomplishment.
We're very
All
proud
of us,
of
I
you.
speak on behalf of the commission and I say, we're so very
Yeah,
proud.
and the sweater
Such an accomplishment.
Yes.
It is.
And before we go to 1C, we'll open the roll again.
Commissioner Paul?
Good morning, sorry I'm late.
We now have 5 commissioners and we still have quorum.
I have no report as for 1C, 1D, IRC chairperson's report.
I do have a report.
All right.
Thank you very much, Chairperson. We are meeting today, the IRC, and we have several things to go over. Requirements for evictions for family occupancy by the owner, just and reasonable guidelines, as well as reduction in housing services are all on our IRC agenda today.
Okay, excellent. So we'll probably have another report at our next meeting, which we'll talk about
Yeah.
at some point. 1E, informational material.
There's no informational material today.
And 1F, this is our rollover item from a couple of meetings for commissioners to bring up before the commission ideas or suggestions on how the commission can take a more proactive role in issues that fall within our jurisdiction. Does anybody have anything? Commissioner Paul.
Hi. So I was wondering if we could, I guess maybe agendize a discussion about whether our commission can weigh in on statewide LSAC reform efforts. So we know that there are organizations around the city and around the state working on LSAC reform, and maybe it would be helpful for us to know about that. And you know, we can talk about whether we'd like to write a letter or make a recommendation or one of those things that commissions do.
Is there anything that you know of that is specifically on the agenda? Like, is there anything imminent specifically that you know of? Right?
I don't know. Maybe the department knows. I was wondering also maybe if the Affordable Housing Commission is doing anything about that. So that's a specific question. But yeah, I do not know. I'm sorry. I'm not entirely up to speed on what's happening.
Would that be something we can, that seems like a full commission discussion that we would agendize in the regular meeting, doesn't it?
Yes, it could be agendized. What I'd like to do though is try and gather some information and then perhaps circle back, let you know about possible speakers, information, and how long we would anticipate perhaps such a agenda item, the length
Right.
it might take,
Okay.
and let you know.
Okay.
Um,
But we can.
in a couple of weeks, people are out right now.
Some maybe.
And then we're also going to have in January, I am hopeful, we had a Coalition for Economic Survival. We'll be having a owner advocacy group, if you will.
Okay.
And I believe it's going to be someone from AGLA, the Apartment Owners Association of Greater Los Angeles.
Okay. So we'll have a busy January.
Yes.
Okay, that's good. That's good. Does that sound good to you?
That
Just
sounds
sort of
great.
shooting for to let staff get some more information
Yeah,
and
that'd be
agendize it
fantastic.
for
Okay.
January. So.
And I'll see if I can learn anything from my colleagues in the outer world. If you guys have anything, send an email to each other.
All right, item number 2, discussion of protocol appeals pursuant to Los Angeles Municipal Code Section 161.1002 at SEC.
Good afternoon, Commissioners. Susan Gosden for the department. And this item has been agendized to let you know of an additional appeal that will be coming your way, or that will be added to your list of appeals that you hear. It will require a full hearing, and what it is appeals of the notices, and these would be the notices that the code inspectors write. And owners may appeal those notices. They would come before your body in the same manner as the other appeals do. There will be a department representative who will have a report, and there will be staff on hand as well, and it will be heard in the same manner. So some of the violations that may come up are violations in the order for maintenance and repair, and it is these violations that is on your handout for item number 2. Owners may be appealing those. The department would be there, as I stated, present their report on why they feel that it was a righteous citation. And the owner would present their side, and then you would make the determination.
So,
And your determination would be you would follow the same perhaps protocol. Did the department err in issuing this citation order? Was there an abuse of discretion? And also, there may also be questions that are appealed. Does the department have jurisdiction to even issue a citation?
And hi, Mr. Gomez. Mr. Gomez is here on this too, right?
Yes, he's present
Yes.
if you have questions or need further information, as is Senior Inspectors Cradolph and Harrison.
Okay, this is for anyone.
Okay.
Is an appeal from a hearing or from a? Is it appeal from a hearing? I'll just start with that.
No, it is not. This is just an appeal of an order, the notice to comply, or the orders that are written by the inspector. It has not gone to a general manager's hearing.
Okay. And who's been hearing these appeals to this point?
The Code Enforcement Division senior inspectors have been reviewing those appeals.
And why are we hearing these now and not before?
The city and department feel that it is the correct under state law and local law that a full appeal is conducted.
And that falls to us as the appeals board of the housing department. Right?
Yes.
Is that the way it is? Let's open the roll call again.
Commissioner Pitt?
Here.
We now have 6 commissioners and we still have quorum.
Okay, does anyone have questions on these new appeals that we'll be seeing? Well, new appeal, we have one, we know we're just gonna see, right? Okay. But we would expect, we would.
Yes. There's another handout that was just given to you a few moments ago, and what it provides some statistics for the last 5 years, and in the far right is the appeals that would be going before the appeals board. And it shows that there was a total of 62, or an average of approximately 12 per year. Yes?
Ms. Gosden, so when we hear these, we would get a report from the department?
Yes.
The way we do on our other appeals, and they would
Yes.
kind of lay out the scenario.
It
for
would
us
be,
and make recommendations?
yes, there will be department report, department representatives, representatives from code, the same setup as
Right.
are done for the current appeals.
And will the report be done by a senior inspector?
If staff will write the report, and I'm not sure it's been fully decided yet who will be the department representative, but it will be someone from our code enforcement division.
Will creating this more formal process create more appeals?
Well, right now, based upon the historical figures, there will be approximately 12 per year. But as they say, past performance is no indication of future.
I think, Dash, are you kind of wondering, like, now that there would be a formal hearing that'll instigate more appeals?
That's what my question is.
Yes, time will tell. We don't know.
Yeah, it is good.
But
We'll see.
yes.
We don't know. Anyone else? Do you need anything from us? A motion or anything? Doesn't sound like you do.
No, this was an
Informative.
informational presentation just to let you know of the additional appeal that you'll be hearing.
All right, then we're gonna move on if nobody else has anything.
Thank you.
Thanks. I would expect that we would, once we get into it, we don't know what we don't know yet. We don't know what the questions will be. So I would expect maybe we will call upon your expertise at some point in the future to answer questions. Okay, thanks very much. Oh, what's the date? What's the date of the appeal that's coming? Do you have it agendized?
Tentatively scheduled for January 18th.
Okay, item number 3, RAC discussion of new business and request to schedule items. Thanks, Mr. Gomez.
You're welcome. Thank you, Commissioner.
Does anyone have anything that they would like to? Seeing none, we are moving on to item number 4, public comment. Do we have any public comment cards? This is an opportunity for the public to address the commissioners on topics of interest and within our jurisdiction. I don't have any comment cards, so we're moving to item number 5, future meetings. We have a January 11th special meeting at which Commissioner Pitts will be
Yes.
Right. Yes. Unless anybody else wants to do it.
We appreciate your service, Commissioner Pitts, in the moment of need.
I don't see a lot of people clamoring over themselves to get to you to fight you for that spot, so it looks like tag you're it. Thanks very much.
As long as I have a steak and some fire, I'll be all set.
All right. And January 18th is a so January 11th is in lieu of our first Thursday of the month meeting, yes?
Correct. The January 4th meeting, it will be canceled. And the January 11th was scheduled in lieu, and then we will be having our regular third meeting of the month on January 18th.
Okay, and then back to first and third Thursday for February.
Yes.
There's a slight possibility I may not be here on the 18th.
Okay.
Same here.
I may be out of town or working. Both of those things are tentative. Also might
So
be out
I'll
of town
put
working,
down
I don't know. I mean,
yourself in your,
I'm just also unsure about the utility.
okay. Thank you.
Okay, then if there's nothing else on meetings, we'll move on. All right, we are adjourning our rent adjustment commission portion of this meeting and convening as the appeals board. It is 12:20 p.m. on December 21st. The appeals board is now in session. Please turn off your cell phones while you're inside this room attending the hearing. My name is Sam Lucas, the person presiding over the appeals board. I will now ask the other commissioners to identify themselves for the record and for you.
Commissioner Carol Brocken.
Commissioner Jane Paul.
Commissioner Jasper.
Commissioner Nestor Hidalgo.
Commissioner Reinfection.
And do we have any translators for the cases?
Nobody has shown up.
Okay.
We
Hi.
do have an interpreter.
How are you?
Fine.
Who are you?
I'm Liz Gonzalez. I'm hearing staff.
Hi, Ms. Gonzalez, hearing staff. Good to see you. Thanks for
Good to see-
helping us.
Thank you.
Yeah, I think we do have an interpreter for the first case because
no-
there were Spanish-speaking tenants who attended the general manager's hearing, but those tenants have not appeared as of yet, so we may release him.
Do we have a Spanish-speaking interpreter for them if they come up?
Yes.
Oh, I see you. Lauren. Okay, we'll swear you in if needed, and welcome. All right, the appeals board review of the general manager's decision shall be limited. This is for everyone, so please listen up. The appeals board review of the general manager's decision shall be limited to those alleged errors of law or fact occurring at the hearing specified in the notice of appeal. The appeals board shall consider any briefs submitted by the parties and any oral argument. The appeals board shall not consider any evidence not presented at the general manager's hearing unless it is newly discovered evidence which could not, with due diligence, have been discovered and produced at the general manager's hearing. Compliance with orders to comply subsequent to the general manager's hearing cannot be heard by the appeals board. The appeals board shall have no authority relative to the interpretation of the administrative provisions of the Los Angeles Housing Code, and the appeals board shall not be empowered to waive requirements of the Los Angeles Housing Code. The appeals board may modify or reverse the ruling, decision, or determination appealed from only upon making written findings setting forth specifically how the action of the general manager was in error or constituted an abuse of discretion. And we will make specific written findings supporting any modification or reversal. So the procedure today is going to be as follows. For each property, we will hear from the Housing and Community Investment Department first, who will present a neutral report for each case. Then we will hear from the appellant, who will submit evidence to the appeals board and or explain why it is believed that the decision should be modified or reversed. Following that, we will hear from any interested third parties. We'll hear from the Housing and Community Investment Department, and then we'll go back and hear from third parties. Then we will hear again from the appellant if there is rebuttal. The rules for this appeals board hearing are as follows. All testimony today will be under oath and subject to misdemeanor penalty for intentional false statements. Only pertinent facts and argument dealing with the subject of this appeals board hearing will be heard. During the hearing, there will be no discussion between the interested parties, and all comments, questions, and answers will be addressed to the appeals board. A written confirmation of the decision will be mailed to all parties. The procedures are being recorded by the Housing and Community Investment Department. If any of the parties wish, upon request, a copy of the recording is available, as are copies of any public document in the case file. The HCIDLA may charge a fee. So let's get to it. Do we have anything on our consent calendar? Yes. Do I have a motion on the consent calendar? If no one, first of all, does anyone want to pull the item for discussion? None?
No.
Then do I have a motion?
I'll make a motion
Commissioner
that,
Stollers.
we deny the appeal of, 588586, case number at 1607 South Manning Avenue, because, the case was, the general manager referred the case up to the city attorney, and we have no discretion over
Second.
Any discussion? None? Let's vote.
Commissioner Lucas?
Yes.
Commissioner Brogdon?
Yes.
Commissioner Pitts?
Yep.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Doggle?
Yes.
There are 6 yes votes, motion passes.
Okay, well, all those here for agenda item number 2A, please come up. That is 6851 North Sepulveda Boulevard,
You guys okay?
and that's case number 626684.
I'm fine.
She checked and said that.
I think she's they're outside.
Every once in a while, you know.
Yeah, because they're longer, so they take some of the noise. Did they step away? It looks like the appellant stepped away. Perhaps we can go
Okay,
to the
let's go to
next.
2B, 6517 West Orange Street. If you're here on that, come up, please. That's case number, sorry, Mr. Craddock. You were all set.
I was already, it's all right.
That's case number 503245-19, and we will hear 503245-20 after that. So come on up if you're here on that case.
I'm a third party.
Okay, thank you for pointing yourself out, and I'll call to you when we get to third parties.
Sounds good.
All right, great. So do I have a sign-in sheet for that case? This.
Just like that.
So let's do introductions, please. Let's start over here with you,
David Robbins.
Mr. Robbins.
My name is Rocio Diaz. I'm the property supervisor.
My name is Matthew Holland here on behalf of the department.
Say your name again, your first name again.
Rocio?
Rocio, thank you. All right, let's raise your hand if you're pretending to testify, and let's swear you in, please. Do you promise or affirm that the testimony you're about to give is the truth and nothing but the truth, so help you?
I do.
I do.
Thank you very much. All right, let's have a neutral report for this case. Give me 30 seconds to get to where I need to be. Okay.
Yes, thank you. This is Matthew Holland on behalf of the department. This case, case number 503245-19, is an appeal of a decision to release REAP escrow funds to a tenant for relocation. Both the tenant and the owner appealed the decision. The owner states that the tenant did not relocate until after violations had been cured. The tenant states that he is entitled to more than the $10,550 that was approved for release. The background of the case is as follows. On September 23, 2015, the department opened a REAP escrow account number 503245 for the subject property. On or about September 20th, the department received an application for the release of REAP escrow funds from the tenant, David Popolo, requesting $20,865.04 for relocation. A hearing on that application was held on October 20th, and on November 9th, a decision was issued approving the release of escrow funds in the amount of $8,050. On November 28th, a revised amended decision was released approving the release of escrow funds in the amount of $10,550. A summary of the hearing is as follows. Rien appeared on behalf of HCIDLA and testified that an application requesting the release of REAP escrow funds was submitted by tenant David Popolo. She stated that the applicant submitted a number of invoices and costs related to relocation. She stated that the tenant's share of the escrow account was $16,325.31. A representative for the applicant, David Robbins, appeared and provided testimony. He said that David Popolo has lived at the property for about 7 years. The agent for the owner, Rocio Diaz, appeared at the hearing and provided testimony. She stated that the owner is not asking any tenant to relocate and the violations have been corrected. They say that they do not agree with the amount of relocation being requested. So I think there was a typo in my report, so I'll repeat the sentence above that again. She stated that the owner is not asking any tenant to relocate and the violations have been corrected, have not been corrected. On November 9th, 2017, the hearing officer issued a decision approving the release of funds in the amount of $8,050. On November 28th, 2017, an amended decision was released approving the amount of money in the amount of $10,550. that concludes the staff report.
Okay, so we have two appellants in this?
Yeah, I'm confused by the, do we have two cases?
Yeah, I'm sorry if there, I wasn't sure how to, I guess, agendize this.
So are they 19, -19 and -20?
Yeah, so there's two, there were two hearings. One was -19 and one was -20. For both hearings, we received two appeals. The applicant, who is the tenant in both cases, appealed, and the owner appealed both cases. So we have 4 total appeals for 2 different cases. This is the first case, -19, where the tenant and the owner
But is
both
the
appealed.
tenant David Popolo or David Robbins?
Yeah, so this is also
Mr. Robbins.
a confusion.
No,
there.
Oh, you're not, I'm
He's
sorry.
not.
First
He's
one is David
the-
Buffalo.
It's a different.
Yeah, he's the appellant for the second case, -20, but was representing the tenant for the first case, -19, acting as a third party or kind of speaking about
And
him.
he's not here. David Popolo?
David Pablo's not here today.
Okay. Well, that's good. We can get through this. That's fine. Okay, so 19-19. Let's hear from the first appellant. Is that you, Ms. Diaz?
I believe so, yes.
Let's call that you, all right?
Okay.
We have 5 minutes for your time. I would suggest keeping a couple minutes back so I can come back to you for rebuttal once you hear from the department and third parties. All right, whenever you're ready, the floor is yours.
I'm ready. Basically, unfortunately, the attorney couldn't be here representing the case today, but we were hired from the owner back in May to take over this property. We were hired as the management company. Tenants, since the beginning, they were very, very difficult to deal with. Not to mention, they disagree with us trying to make the repairs. They were really comfortable for the past 2 years, living under these conditions. I'm assuming they were happy with the 50% discount that they were receiving. We did our best as a property management to try to resolve the issues, which they made it a nightmare for myself because I was the one in charge trying to resolve everything. Once all the repairs were cured, either they wouldn't want us to go in and do a reinspection. Finally, the inspections passed, everything was done. As soon as they knew that everything was cured, we want to move. We don't want to be here. We try to work everything with them. They were in a better place as before that they were comfortable in. They just didn't want to work with us at all. They said they got instructions from the inner city and here that they were entitled to all the money that they had been paying into the city. Which, the owner's not denying any relocation fees. He's just, he went through a breakdown. He's the older person that had several health issues. That's the reason the property went into Reeve. It wasn't because he didn't want to do the repairs. It was just an emergency problem that he had. And the owner's not willing to pay for relocation fees. That's not the case. He's willing to pay just what the law allows. He doesn't want the tenants to abuse the situation as is because it's noticeable that they're abusing the funds only because they think they're entitled to all the money. It just seems unfair because they didn't, since the beginning, they were really, it was really hard to work with these tenants. And now they're just suggesting more money than it should without providing evidence. They're not providing invoices they're just estimating. Okay, so I'm gonna move out of state. I estimate I'm gonna need $8,000, $10,000 for this, which I just asked for you guys to consider and to review all the documents provided, not just assuming and, that's basically what I needed to say.
All right, you've got some time left. We'll come back to you after we hear from other parties. Let's hear from staff.
Yes, thank you. This is Matthew Holland again for the department. This case is very similar to a case we heard last week. It's the same property, different tenants. There was some confusion, I believe, by the hearing officer because there were 2 applications by 2 different tenants, both of them with the first name David, and I think she maybe missed them or mixed them up a little bit. So there was 2 decisions issued. The first was getting the wrong David, the wrong money, kind of swapping the names in and out. The
That's
second
the
one,
reason for the amended decision.
yes, the amended decision was meant to correct that. So there was some
that's-
confusion, and I'm sorry for the tenants and the owners kind of having a hard time understanding maybe what was happening. But I do believe the right determination was made in this case. The total amount for David Popolo, who I'll stick with for this case, that was approved for a lease was $10,550. He requested over $20,000. $10,550 is what is authorized to be released for a tenant in his situation. In the RAC regulations, at section 1200.12 B2D Roman numeral 4.
Say again.
1200.12, letter B, number 2, letter D, Roman numeral 4. The hearing officer shall calculate the amount of the relocation based on the greater of either of the following: the monthly rental disparity between the tenant's rent for the subject unit prior to the reduction and the market rent for a unit of similar size, or the amount to which the tenant would be entitled to for eviction subject to Los Angeles Municipal Code section 151.09G. There wasn't any analysis of a monthly rental disparity, so I don't think there's any way for the hearing officer to have made a determination on under that item. But the amount that the tenant is entitled to under LAMC section 151.09G is spelled out in this rent stabilization bulletin, which I'm just going to read from now because I think it's simpler. Basically says that a tenant, an eligible tenant, is entitled to $8,050 if they have less than 3 years at the property, and $10,550 if they have more than 3 years at the property. They may also be eligible for more if they're a qualified tenant, which includes having a disability, being of a certain age, having minor children, but none of that was testified to or argued, and the tenant didn't appear at the hearing to make those arguments. So as an eligible tenant, and it was undisputed that he had been there for more than 3 years, he was entitled to $10,550. That was the amount that was approved. I think the way it got there was probably a little confusing for both the tenant and the owner, but I think the right decision was made, and I think the decision should be affirmed, possibly with a clarification by the RAC that it was approved, because that's what he's entitled to under LAMC section 151.09G as illustrated in this bulletin. I can submit the bulletin into evidence if that helps. Let me know.
And I think it's in our book too.
Is the bulletin in the book? The current bulletin? It's an updated bulletin from earlier this year.
The bulletins are not in your binders. It's the regulations. So could we pass those out, please?
Right. Is that all from you, Mr. Rowland? Or do you have?
Yeah, could you pass one up to the owner and the tenant too, please, Elizabeth? Thank you. Yes, that's all for me. Thank you.
Okay, we have somebody that's told me they're a third party that wishes to speak on this matter. Mr. Robbins?
Yes.
Yeah, okay, you have 5 minutes as well.
Okay.
Well, let me ask first, are there any other third parties here on this case that's come in since then? All right, whenever you're ready, Mr. Robbins.
Okay, Mr. Popolo asked me to represent him here as a fellow tenant in the same building. As to what the appeal is addressing, aside from the manager's comments about people agreeing or not, or disagreeing with what was going on, that I don't see that in anything that was already decided in the initial case. What Mr. Popolo is contesting is that in fact, it says here in the decision, the original decision, that the 1200 point, is it point 12 or point 13, by the way?
Mr. Poland, point 12 or point 13?
I have 1200.12.
Okay.
It may, the regulations were updated in early 2017, so there may be references to a prior version that was point 13.
Okay. At any rate, the deciding general manager said that no evidence was given by the tenant as to that particular regulation, and the monthly rent disparity between the tenant's rent for the subject unit prior to the REIT reduction and the market rent for a unit of similar size for 42 months, or the 151.9G, which is, and they say it is whatever the greater of the other. He contests that he had no knowledge of this law and was only guided by his contacts with the intercity law to suggest what they need to do as far as presenting their reasons for moving and for evidence as far as the cost of it. He gave you a detailed list with receipts detailing what the actual move was cost. The regulation says that, and he also did state what his rent is. If you were to take the first part of this regulation into consideration, if there's a disparity in the rent, for the rent that he's paying, the new rent, there is a disparity. For any place in the area, including our place now that they've started to rent it, there's quite a disparity from the rent we were paying before Reeve. So if you take this into consideration, is it not the difference of the reduction of the rent times 42, which equals far more than the decision made? By the general manager extrapolating that from the amount of rent that he did have, that general manager would have been able to extrapolate that that amount is quite different than the amount awarded. So it's whatever the greater of the two is, up to the amount available in the escrow. And I think that's it. Oh, yes. The regulation that they cite as far as their reasons for the maximum amount for relocation is 2 times the rent, is based on an ordinance or a regulation, I'm not sure which. It's the 1.5, but I'm sorry, they had cited it in the appeal, I can't think of it offhand, but it basically says 2 times the rent before Reeve. But that particular regulation is not in the REAP section of the code. It has nothing to do with it. It's not. Yes.
You have 1 minute.
Okay.
Just giving you time.
That's all. That's really all I have to say.
All right. Thank you very much.
Okay.
So now what we're going to do, we have appellant, staff, appellant / third party, a representative for an appellant, Mr.
Right.
Popolo, right? So now I'm going to come back to you, Mr. Holan, and then we're here. So we have appellant, department, appellant, department. If you have anything to say as to Mr. Popolo's contention.
Not a lot. I guess a few things I'll say. One is just to make it clear regarding the first portion of the regulation where you can use the rental disparity to determine your relocation amount. That is the rental disparity between the current unit before it was placed into REAP and a comparable unit. It's not necessarily the unit you're moving into. It has to be a unit that's comparable. Comparable isn't really defined, but you can't move from a 1-bedroom to a 2-bedroom or to a different city or something like that. I think you need to keep it comparable. And there just wasn't evidence of that at the hearing. I understand the position that it wasn't explained to him. If there was a inner city group, a nonprofit group that gave him advice, I don't believe they intended to maybe give legal advice or counsel. They didn't represent him at the hearing or fill out the application. They may have just explained what his rights were, which he did have the right to request relocation amount. But the fact that they or anyone else didn't tell him that here's exactly how much you get and here's the calculations and here's how you do them, I don't think there's anyone whose responsibility that is. I understand that it makes it harder. But I don't see how there was an error or abuse of discretion given that he did not appear at the hearing and didn't do that analysis. I think that the amount under LAMC 15109 is appropriate in this case, given all the, I guess, evidence at the hearing. That's all.
So now, Ms. Diaz will come back to you. Let's hear from you again if you have anything else to say after you've heard from the department. And you had 2 minutes left on your time.
Basically just a question. They mentioned that the amount that we're renting the units, it's at a higher rate. I was curious to know where he's getting that from. So I don't know if
One of the tenants that moved in?
Please don't.
Oh, I'm sorry.
All questions and answers will be directed to the appeals board. Thank you. So therefore, some questions might have to remain rhetorical. Because if I don't know the answer, I won't be able to ask them. Okay, anything else?
No, I just would like to add that we're not renting the units at a higher amount. We're following the law instructions. So we were aware that it has to go back to the original price, which is $2,400. And even though the units might be at a higher price, we're doing what we're supposed to do. So there's no units being rented at a higher price than it should. That's something that I want to point out.
Thank you very much. Anything else?
That's it.
Okay. And now, Mr. Popolo through Mr. Robbins, I'll come back to you.
Yes.
You had time left on your 5 minutes as well. If you have any rebuttal after you've heard again from the department on yours.
Yes,
you had 1 minute left on your time.
As to the department, the going rate in our area, by any stretch of the imagination or any stretch of fact that's there are most rental units are well over what we were paying now. The area has gotten higher in value because of all of the purple line work and the buildings and so on and so forth. The fact that I don't understand the fact that if he didn't know that he had this regulation at his disposal, how he could calculate it. I mean, it would be a lot simpler just to calculate based on that and give a difference in the two costs of rent before Reeve and the current value of rent, rather than listing all of his deductions. I mean, all of his things would have been easier.
Thank you very much. I'll stop you there. That's your time. All right, now I don't have anybody else signed in for this case, so we've heard from everyone. Case is yours, Commission. Do you have questions or comments?
I just think that the general manager, the amended sum of $10,550 is, like Mr. Nolan said, is the eligible amount for somebody who's been there for 3 years. And I would personally affirm that amount, especially as it is in line with LAMC 15109.
I just have a question of how the person, Mr. Popolo, caused to be evicted. I don't understand how this whole relocation process got started.
Yeah, I'm sorry.
It doesn't make sense to me.
So Mr. Popolo chose to relocate, voluntarily relocated, which you have the right to do. Under Reeve, you're allowed to relocate. I mean, you're always allowed to vacate your unit, depending on your lease. You can request money to be released from an escrow account as long as you apply before the case is closed, before the violations are corrected, which Mr. Popolo did. So you can request money to be released for relocation if you're living in a unit that's in Reeve.
So any tenant in any unit in Reeve has the right to request relocation during the Reeve period?
While the violations,
I didn't understand that.
while the violations are there, you're just only entitled to the money that you deposited yourself. You're entitled only to your deposits, not the entire buildings.
Up to
what the ordinance allows.
Oh, I see. So if you didn't deposit enough for relocation, okay.
Oh, Commissioner Paul.
I have a question. Mr. Holland, I just want to, confirm that it's the appellant is responsible for understanding all of the rules and regulations that they're going to utilize in their appeal. So that in this case, it's unfortunate the tenant didn't necessarily know that they could have potentially brought in different kinds of evidence to, for example, show a difference in rent in a comparable unit in the community. Is that correct? So it's the tenant is, or the appellant, whoever they are, is responsible for knowing what they should bring as evidence.
Yes, if there's a request for a release of funds, the applicant should be requesting, should be finding out what they're eligible for or not. We will try and help, but it's their responsibility to make their own request.
Okay, and in this case, if there had been additional evidence, they could have theoretically gone from that $10,550 that's the prescribed amount to up to their Reeve balance.
Yeah, theoretically, there's really no absolute cap. The cap is, I guess, whatever the monthly rental disparity is for 42 months. There's no maximum amount. You just have to show it based on what is allowed.
Okay, thank you.
While we continue to discuss, I'm going to turn to what's given to us as new evidence, but I think I have this
Also, Ernesto has a question.
as part of the appeal. I'm looking at a document that's entitled Addendum Appeal made by 6517 Orange Street Incorporated. And it is a 3-page brief that explains the grounds for appeal from the appellant. The landlord appellant, right? I think this is part of your appeal, your regular appeal. Do you want to speak to this? Am I wrong?
You're right.
Oh, okay.
I wasn't supposed to be here today. It was a last minute thing. So I didn't know if he had, I didn't do the appeal.
You didn't know if it was here or not,
Yes.
and maybe, okay, so I'm going to say we don't. If you want to withdraw your brief, we don't have to consider it as new evidence because we have it as part of the
I
appeal.
withdraw, yeah,
Okay,
that's fine.
we don't have to take it. All right, thanks very much. That's all I had for this case.
Ernesto has a question about
Yeah, yes, Commissioner Dolan.
I'd like to know how you determine what the difference is between when there's a difference in the 42-month rent for relocation. Do you require something in writing to evaluate that there is a difference, or what's the standard for that?
Yeah, there really isn't a specific standard. I think what I've seen before from tenants is the copy of their original lease, along with a rental advertisements showing what costs are for similar properties, and just saying it was $1,000, now this is $1,200. But there's really no. To be quite frank, most tenants don't go with that approach because the amount under 15109 is usually more. So that's usually what I've seen is they just default to the ordinance and take that amount. But I have seen advertisements and a copy of the lease and then just the difference multiplied. That's the only example I can think of.
Anybody else have questions for either of the appellants or for the department? Do you have a question for us?
Yes. Did you consider the written statement from David Popo in regards to his appeal?
We have that as part of our appellant packet. Yes.
Okay.
Thank you very much. I think Mr. Robbins is referring to what's on our page. What I have is my page 21 of our, for the record and for your information.
Chair?
Yes.
With this, I have a question. It says that in the introduction
To
this case, it says, I guess this is the owner's appeal. The owner states that the tenant did not relocate until after the violations had been cured, or after the violations had been resolved. So, in terms of I'm not sure if we addressed that appeal, I think what we're talked about is the tenant's appeal, so I'm just not trying to unwrinkle this. That the date of the tenant's request for relocation is what's up for debate.
And I think the landlord's contention is that they were fixed, and then
Right.
he applied for the money.
Oh, well,
Okay,
But then-
he's right, we haven't really heard that.
So I guess I have a question then for Mr. Holen about the date of the inspection that shows that all the violations have been resolved. Right, I think that would be helpful.
Yeah. So we might have I feel like we have a distinction between when you think it's finished
Right.
and when there's actually been that
An inspection.
inspection.
Yes, I'm pretty certain that I have that in here. Give me a moment to get the right page in the
No pressure.
packet.
There's a lot for us to consider here, so we'll.
So in the staff report that staff submitted at the general manager's hearing, they had the case manager sign off as September 21st, 2017. The application was received on that same sheet. Sorry, that's on page 31 and 32 of your packet. On that same sheet, she has the application received as September 20th, 2017. So that is one day before the violations were signed off.
Okay, thank you.
Okay, I have heard from both appellants. We'll take motions separately.
On the two separate appeals.
Yeah, so whenever your questions are exhausted and you feel like you've had enough information to make a motion, the floor is open for such a motion.
I'll make a motion.
Commissioner Paul.
I want to object. On case 503-245-19, I'm going
As to the what?
As to the appeal by the owner, that the tenant did not relocate until after the violations had been resolved. I move that we uphold the decision of the general manager due to the fact that although we are very grateful that the violations had been resolved, we've had this situation before, and the tenants are still have lived under the conditions of violations. And so they have up until that date. So my motion is to uphold the decision of the general manager and deny the owner's appeal.
I'll second.
Is that?
We can, well, we need to take the second.
Well, if they're,
Speak up,
We
if we're
have
gonna,
written
if
that
we're gonna
way.
discuss, speak up for the mic.
yeah. Okay, it's not actually written that way, it's two separate, it's one appeal by both the tenant and the owner, appealing decision. It's not actually written in the appeal form, it's two separate questions. Is it, Matthew?
Well, there's two separate appeals. The owner and tenant
I
both
know.
submitted an appeal. I guess we agendized them together, so I
Okay,
wouldn't have a
that's-
staff
they're
report
agendized together, that's why
saying
I
the
thought they were
same
the same.
items.
I mean, it's fine if you want to do it separate.
I think it's cleaner to do two.
Yeah, I think it's
because
confusing
safer.
enough. If we
It
can
really
take
is.
two, let's
Okay.
just.
Well, then let's do James.
Okay. There's a motion and a second on the floor. The motion is up for discussion. Does anyone have anything? I'm gonna vote for the motion, but under protest. It's the letter of the law. I don't think it's within the spirit of the law.
I don't either, I agree 100%.
Right, because of the day before.
Because
Yeah.
the day
Yeah, yeah.
before.
Yep.
So, anybody else want to say anything before we vote?
Well, I would just say one thing, that when we had a case like this just a few weeks ago, that it was also close, the timing was close. But what we learned from the tenant was that they had been looking for a place to live for quite some time. So, and we can, there's no way we know that or can prove that, or the tenant can prove it.
I don't think
You
it
know,
was a day, though.
No, but that you can be looking for a place to live for a year, right? And living with violations for a year, and you finally get a new place, this is all theoretical, and it happens to be the day before the inspection. So it's hard for us to judge what those we cannot judge what those circumstances were. So I don't know how the law could be written differently. So it's a messy thing, but in fact, we don't know really how long this tenant has wanted to move out. And also we had this question where the owners said that they felt taken advantage of because the tenant had a rent reduction, but in fact, the tenant lived with violations, and that's why they had a rent reduction. So I just wanted to sort of affirm that from the tenant's position.
Thank you very much. Anyone else before we vote?
And I just wanted to say also that if you're living in an RSO building and say you've been there 5 years, so your rent's, gone up 3%, in those 5 years in the city of Los Angeles, rents have gone up 20, 25, 30% in some neighborhoods. So trying to find a place that's comparable in your neighborhood would be very difficult. And we've seen tenants come forward who had to move all the way to Riverside, all the way to other counties just to find a similar 2-bedroom apartment. I agree with you completely that that what we're voting on is the letter of the law, not the spirit of the law. But I also think that there's a larger issue here where tenants are living in untenable circumstances and finding it very, very hard to find anything that they can afford because market rate is impossible.
Thank you. Anybody else? All right, there's nothing else. Let's call the question.
Commissioner Lucas?
Yes.
Commissioner Bartlett?
No.
Commissioner Pitts?
Yes.
Commissioner Paul?
Yes.
Commissioner Stoller?
No.
Commissioner Doggo?
Yes.
There are 4 yes votes, motion passes.
Okay, thanks very much. Do we have another motion? Any others? We need a motion on the appeal of Mr. Popolo. Or questions, or discussion.
All right, I'll make a motion since I have a lot to do today. So I'm going to move that we uphold the decision of the general manager about the amount that the tenant is entitled to, because that amount is as per our LAMC 151.09. And we have in front of us a rent stabilization bulletin that states the amount of $10,550 for an eligible tenant. And the tenant did not provide evidence for the evidence needed to validate additional dollars.
I second it.
Any discussion? All right, seeing none, let's do a vote, please. When you are ready.
Commissioner Lucas?
Yes.
Commissioner Bartlett?
Yes.
Commissioner Pitts?
Yep.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Doggo?
Yes.
There are 6 yes votes, motion passes.
All right, thank you, Ms. Diaz. Thank you, Mr. Robbins, for appearing for Mr. Popolo. Both of the appeals have been denied, and the decision of the department is upheld. All right, so that is -19, -20. You're still here on dash 20, Ms. Diaz, yeah?
Yes.
Okay, thank you. And Mr. Robbins,
I'm the tenant.
you're the tenant on dash 20.
Yeah.
Do you want to come up, or are you
Yeah.
good where you are, or?
I,
Well, you can do whatever you want. My only concern ever is that when people sit in the gallery, they can't be heard by the mic, but you have no trouble being heard by the mic.
I got pretty good projection.
Yeah, so sit where you want to sit.
Okay,
and-
very good.
All right, so that's A, and now this is B.
Yeah.
Okay, so everybody just give us a couple seconds to literally house clean. And let's I need this.
C. Okay, C. Okay, yeah, thank you.
Okay, we all set?
Yes.
All right, so am I, whenever you're ready, Mr. Holland?
Yes, thank you.
Staff report.
Yes, thank you. This is Matthew Holland with the staff report. This case is an appeal of a decision to release Reeve escrow funds for case number 503-245-20 to the tenant for relocation. Both the tenant and the owner have appealed this decision. The tenant states that he is entitled to more than the $8,050 that was approved for release. He said he was not aware that the amount of relocation was dependent on his age and longevity at the property, and he would have testified differently had he known that. The owner states that the tenant has not relocated and the violations no longer exist at the property. The background of the case is as follows. On September 23, 2015, HCIDLA opened Reeve escrow account number 503-245 for the subject property. On or about September 6, September 6, 2017, the department received an application for the release of Reeve escrow funds from the tenant, David Robbins, requesting $20,400 for relocation. A hearing was held on October 20th, and on November 9th, the general manager issued a decision approving the release of escrow funds in the amount of $10,550. An amended decision was issued on November 28th, amending the dollar amount to $8,050. A summary of the hearing is as follows. Karina Casillas appeared on behalf of the department and testified that the application requesting the release of Reeve escrow funds in the amount of $20,865.04 for relocation was submitted by the tenant, David Robbins. She stated that the applicant submitted a number of invoices and costs related to relocation. She stated that the applicant's share of the Reeve escrow account was $25,859.67. The applicant, David Robbins, appeared and provided testimony. He said he moved into the property in April of 2015. He said he is the only occupant of the unit and he does not have a disability. He said his moving expenses estimate is over $20,000. The agent for the owner, Rocio Diaz, appeared at the hearing and provided testimony. She objected to not receiving copies of the application and supporting documents at the hearing. She said that the inspector cleared all violations on September 21st, 2017, and all repairs have been corrected. She also stated that the tenant is not being asked to leave and they are not trying to relocate the tenant. The hearing officer said she would provide a copy of any document she is accepting into the record to the owner's representative. A decision was issued on November 9th, 2017, approving the release of Reeve escrow funds in the amount of $10,550. Then, on November 28th, an amended decision was released approving the amount of funds only in the amount of $8,050 to the applicant. That concludes the staff report.
Okay. So let's do what we did last year. Give everybody equal time and opportunity to be heard. Let's start with you, Mr. Robbins,
Okay.
as one of the applicants, as one of the appellants.
Right.
You have 5 minutes whenever you're ready.
Okay. In my appeal, when I submitted it, I submitted some pieces for your consideration. One is a copy of my driver's license, which shows that I'm 62 years of age. It's over 60. I did not know that this regulation existed beforehand until I got the ruling from the hearing manager. Upon seeing that, I am entering that as evidence to reconsider the amount. As one of the reasons to reconsider the amount to a higher amount based on that particular ordinance or regulation. The other thing I did was I gave you a letter of justifications on error and of fact, and I also gave an amended of that today, which you have copies, along with a stapling of, I believe it's 6 or 8 properties in the area, and the rents they are going for based on westsiderentals.com. What I'd like to contend is that, again, with the RAC regulation 1213 or 12B2D4, the reason why I'm entering these second sets with the rent and I'm asking your consideration to accept them into evidence is the examples of the rent disparity, plus the second letter that I gave you, or the appended request for release of funds on the appeal, which shows how those rent examples show the difference. And this being the greater of the two, given me as far as that, I want to enter this as evidence. The regulation states the general manager shall calculate the amount of the relocation based on the greater of two following. Okay. Based on the average rent of 6 apartments for rent in my area, which you have copies of, the rent example cite total a difference in my rent before Reeve till with an average of those comes out to $682.52. If you times that by 42, that comes out to $28,665. I had asked for $20,000 based on estimates of what it would take me to move from the apartments that I have been looking at. I have been looking since June for an apartment. I had decided 6 months before that I've had enough of this ignorance of what was needed to be done to the building. I didn't want to play owner or play landlord anymore, which is what I was basically doing. I wanted to get out. I have a business to conduct, which I conduct at home, and I needed to at least get my money's worth as far as my rent is concerned, being not a substandard condition.
A minute and a half.
Okay.
A minute and a half.
The other part of this appeal is based on the first letter of the attachment of the notice of appeal, which I've already touched on, which is my license. I didn't know I had this. I didn't know there was a reason to give my age, but that is my age. My age is 62. That was used as a basis, I'm assuming, for the final. The amount judged on, as well as the fact that I'm there under 3 years. That may be so, but that's 2 years and 7 months since the date of this request was first filed. That's nearly 3 years. Plus, it also, the way I look at it is, it's the lesser of the two between those two, and these examples that I give you in new evidence that I submitted today.
Okay, thank you very much. What does the department have to say? You have 5 minutes.
Thank you. This is Matthew Holland for the department. So this case is different from the last case. The issues are the same, but I think the most significant difference in this case, in the last case, is that the hearing officer asked questions and got evidence regarding whether or not Mr. Robbins was a qualified tenant or an eligible tenant. A qualified tenant receives more money under Section 15109. The factors to be considered a qualified tenant are that you are a handicapped or disabled tenant, you have 1 or more minor and dependent children, or you are 62 years of age or older. For whatever reason, the hearing officer asked about disability status and minor children, but did not ask about Mr. Robbins' age. Perhaps because of his youthful appearance at the hearing, didn't think to do it. But it seems pretty uncontrovertible to me that Mr. Robbins was and is 62 years of age, which makes him a qualified tenant. And the decision assumed he was an eligible tenant, which gave him, as a tenant with less than 3 years, $8,050. But someone of his age is entitled under the ordinance, under the bulletin, to the qualified tenant amount of $16,950. And I believe that that is what the hearing officer would have provided had she known his age. And I think that based on the evidence that I see that was submitted at the hearing and the fact that I think the driver's license as submitted now should be considered as evidence that was not submitted due to, I think, a reasonable mistake. It should be considered as evidence, and the decision should be affirmed for relocation with a modification to give him the larger amount. Because that amount is more than what he said the difference is, I don't think there's any reason to discuss the difference for me. The disparity between the rental unit dollar amounts, because I think that's the more appropriate dollar amount, is the $16,950, which is on the same bulletin I submitted into evidence earlier. That's all from me until there are questions.
Okay. Ms. Diaz, let's hear from you as a third party to Mr. Robbins' appeal. You have 5 minutes. And then after this, we'll come back to you on your appeal. All right, whenever you're ready.
You know, I'm going to sound like a broken record, but just going back on...
We know, but
okay.
You're forgiven. It's
unusual
circumstances, but you have to say we got to say.
Yeah, I just wanted to point out several things. I understand that, you know, tenants take a while to look for a place, but taking 2 years to be comfortable in a place, and then suddenly when the owner, representative, attorney hires a management company, and we do our best in our power to fix everything, to make them comfortable, and they have this anger towards me, because I was actually the one scheduling everything. I think this, abusing the law and try to take advantage of the situation, it doesn't take 2 years to find a place. If you're not comfortable, why stay 2 years? And then as soon as everything's repaired, okay, I'm done, I'm moving. Give me $20,000 because I pay 50% of my rent. You know, I'm just describing what I went through, and I'm just putting everything out there. It's just, it seems really unfair to use the law at your convenience. And I understand if one person did it, but the whole property decided to flip and go as soon as I repair everything, it seems really odd for every single tenant. It just seems like they take advantage of the situation, and it's just not fair. Maybe the law allows it to abuse the rights of, you know, the owner, because that's the way I see it. He's not disputing to provide each tenant with whatever the law allows, but to ask for more or try to bring in other things, it just doesn't make sense to me. You know, and I'm not an attorney. I'm just putting out there what I think it's fair and what is not fair. You guys are the ones here representing the law, so you guys will make that decision. But again, I just want to point out that living under a situation for 2 years, it appears to me that you're comfortable. And then when you see the opportunity to get $20,000 per tenant, because each tenant applied for the same amount, it just seems kind of fishy to me. That's the only thing I have to say.
Thank you very much. We'll come back to you, Mr. Robbins, for rebuttal on your appeal. You had 20 seconds left on your time.
On my appeal.
Let's
okay.
Let's see what you can do with 20 seconds.
Okay.
All right?
I reject the assumption from the manager that it was comfortable. I reject the assumption that, you know, however we've been looking, however long or short we've been looking, has been based on many factors, and that's an individual thing between the tenants. Because we had what was available to us, gave us some sort of a bar to at least know, you know, that it would be worthwhile to go through yet another aggravation, and that is these hearings and the waiting and all that. I have not been able to move until after
Let's finish the thought. and then we'll-
October because of a medical surgery that I had. And I was not able to go anywhere before September.
Thank you very much. Ms. Diaz, let's come back to you, please, on the appeal of the landlord. To the extent you have more arguments to make, now would be your time to do it. You have 5 more minutes.
I'm done, sorry.
Does the department have anything else to add as to the appeal of the landlord?
This is Matthew again for the department. I think I'll just clarify. The application was received before the case was signed off by the inspectors. I believe in this case it was not such a short time period. It was 3 weeks, about 3 weeks before they received the application. And I also will I guess state I don't think it's the department's not going to consider make assumptions about motivations for applications. If there is actual evidence that this application was made in bad faith, that the property was kept in Reeve longer than it should have been by the tenant so that he could make a request for relocation, then I would be willing to listen to that sort of argument. But I think just based on assumption because of the timing, I don't see how I can recommend reversal of the decision for that reason. I think the decision should be affirmed with the modification that I recommended earlier still.
Okay, Mr. Robbins as a third party to the appeal of the landlord.
I just wanted to say I'm so impressed, Sam, that you're able to.
I know.
It's,
Just do the
I'm
mental
hanging on by a
gymnastics
thread,
required.
so that's, yeah.
It's like Sam has multiple personalities.
Okay, to the landlord's appeal.
Yes. To the extent you have new information or things you want
Right.
to say about that.
Basically, I'll reiterate that his reasons for appeal are based on one of the ordinances that he cites as to the maximum amount is from an ordinance that is not under Reeve. As far as their assumptions about, as he put it, as the lawyer put it in the appeal, that I'm skating by with a reduction of rent. That's kind of offensive. We're all people of means in this building, and we have our careers and our livelihoods. And to be called a freeloader because the building is not up to code is offensive. And I think that that's it.
Okay, thank you very much. And last but not least, Ms. Diaz, rebuttal on your appeal.
I
to
got
what you've heard
nothing
from
to
me.
say. I said enough. I'm sorry.
Thank you very much. Okay, Commission, it is your case, your cases.
I have a question for Mr. Holland. Under the qualified tenant description in our relocation assistance rent stabilization bulletin, it says a qualified tenant is any tenant who on the date of the service of the written notice of termination is 62 years of age or older.
Yeah. So if I think I understand your question.
I'm asking.
Yeah. So the law regarding relocation for a property in Reeve makes reference to a law regarding no-fault evictions, basically. So the bulletin's about no-fault eviction, so that's why the date of the written notice of termination is in there. But I think the intent to me is clear that within Reeve they're making reference to this section that is dealing with, I guess, the factors to be considered to determine someone who's a qualified tenant. So there is no written notice of termination. Because there is no eviction. It's just a reference to this, so you can understand how to arrive at the dollar amounts. So to me, I would say the clear important date is the date that he made a request for relocation, and he was 62 at the time of his application.
That's what I was wondering.
Yeah.
Thank you, Mr. Holland.
But it doesn't say that.
No, it doesn't.
No, it does not say that. I think because of it's a reference to another law, you have to. I feel I have to make a kind of assumption about why they would make that reference to this law.
Yes, it's written as if somebody's tenancy has been terminated.
Yes.
So we're saying the request for relocation is the equivalent of a notice of
That's what
termination.
I'm trying to figure out. Does that jive with the age requirement?
That's why I interpret the intent of the regulation by making reference to this. Yes.
Also,
Anybody else? Questions, comments?
I just want to make note too that a 50% rent reduction means that the violations were pretty severe. And if they were able to pay in that long to get that amount in the escrow account, that means they were at that high severity of violation for a really, really long time. It doesn't matter how low your rent is, if the conditions you're living under are harmful to your health. I just wanted to say that.
Thank you. Anyone else? Questions, comments? Did the landlord at any time ask for funds to be released to make repairs from the rent escrow account?
No, sir.
The floor is open for discussion and for questions and for motions. Reminders that we should probably take motions separately on each of the appeals. And we have new evidence that we're being asked to consider.
there's two.
Okay, we have, I think, another brief from the landlord's agent, that I think is again part of our appeal packet.
What does it look like?
Okay, yes, and for the record, we will identify them. One is a brief, a 2-page brief entitled Addendum to Appeal made by 6517 Orange Street Incorporated, that I think is part of our appeal.
And you're right.
So 2C tenant and 2C for management?
That we have discussed, we have considered already. It's not new evidence because it was part of the appeal packet. So it's not actually new evidence, we've considered it already.
Right, so we have this all.
So
It was my mistake.
Nope.
Do you withdraw your?
Yes.
Okay.
Thank you. And Mr. Robbins has submitted what I think we can characterize as a 1-page brief on his argument for his appeal with 1, 2, 3, 4, 5, 6 pages of comparable apartment listings. Is that what I'm looking at? That go to his argument of comparability. Mr. Robbins, this isn't part of your, this was not part of your appeal packet, right? This is actually new evidence?
This is new evidence, yes.
I will move to approve the new evidence as listed,
I'll second it.
as presented, I should say. And there's a second. Is there any discussion? Okay, let's vote, please.
Commissioner Lucas?
Yes.
Commissioner Broderick?
Yes.
Commissioner Fix?
Yes.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Donald?
No.
There are 5 yes votes, motion passes.
All right. Motions.
Do you want them separate again?
I'm sorry, can I just ask a quick question?
Yep, floor is
Mr.
open.
Holland, you were recommending that, that we could revise the amount in our motion as opposed to like amending or some other mechanism?
Yes, that was my recommendation. Because the issue here is the age of the tenant, and it's not really, to me, debatable, I don't see a point of another hearing.
Well, I am willing to put forth a motion on CCRIS case number 503245-20
Okay.
in regards to the tenant's appeal in view of the newly produced evidence and of the age of the appellant, making him a qualified tenant at the time frame that we're looking at. I would move to amend the amount that the general manager initially approved, which was, I believe, $8,050, to the correct qualified tenant, i.e. a tenant over the age of 62. And that amount would, I believe, be $16,650? $950. $950. Why don't I have that? Oh, very good. And this is in our Relocation Assistant Rent Stabilization Bulletin, LAMC 15109.
Okay, there's a motion on the floor. Is there a second?
I'll second.
There's a motion and a second.
$16,950 is the qualified tenant with less than 3 years, because it is less than 3 years, this tenancy.
Can I ask a question?
Yep, it's open for discussion before we go.
Yeah.
The appeal by the tenant that we have a motion on is that he's entitled to more than the $8,050 because he was not aware of that it was dependent on age and longevity and would have testified differently had he known that. That's the appeal. The new evidence, though, this letter on the cover of the new evidence is actually a request for additional funds. And so, but that's not in our original appeal. So we're not actually weighing in on this additional request. Is that correct?
Is that why you voted? Yeah.
What, are you talking to Ernesto?
Yes.
Yeah, well,
That's
let's
his no vote.
talk about it.
It is in the appeal. In the sewer staff based on.
Correct. The error of fact is the appeal, the error of age.
Right.
But the appellant has submitted a document asking for additional funds unrelated to the age issue, and that's not in our appeal. So is that something that he would have to enter a new separate appeal for?
A Matthew question?
If the time has passed, it wouldn't be a timely appeal anymore.
Right. Mr. Holland, do you have an opinion about this?
I'm not sure I entirely understand the question that's being posed. I'm sorry.
I think the concern is that we're being asked to consider an appeal that's on different grounds.
I think I understood the appeal by the tenant. Sorry if this does not answer your question, but I believe the appeal by the tenant would be I should get more money for relocation because A, the disparity between the rental markets and the current the actual rent is so much money, and that entitles me to more. Or B, I'm age 62. So basically saying under either section of the regulation, I am entitled to more. He submitted evidence regarding the disparity, which my position was when I argued is that should be ignored because it's the greater of the two is the age. He does talk about his age. He says, the last paragraph, I have lived at this residence for over 2.5 years. I would ask as to age, since I am 62 years old, I would think that this would also have no negative impact on the decision amount. I would ask any negative result that exists in the manager's decision be reconsidered. So I understood him to say, reconsider. The phrasing is a little awkward, but I read it as reconsider the dollar amount being considered as because my age is sufficient for a higher dollar amount.
Okay, so the appeal is not appealing anything past the age issue.
And I think it's appealing both. It's appealing, saying I deserve more money under both sections.
Okay.
And I'm saying the only one that matters because you're entitled to the higher of the two is the age because that entitles him to the higher of the two. That's the department's position.
It is higher than the original amount, but it's not higher than the requested comparable amount.
In his appeal, he states.
I'm sorry,
He believes he's entitled to $20,000.
That was the original application, but in his appeal, after I think understanding the regulations more, he says it can be extrapolated that there is a $350 per month disparity from my rent before REAP. Multiply that by 42 months allowed under the regulation. That totals $14,700. Since $14,700 is less than the amount he's entitled to as a qualified tenant, I kind of just dismissed it.
Thank you. And what page are you on?
Oh, sorry, that's page 19. That's the attachment to his appeal. It's in the middle, I guess, paragraph. The number is number 2.
I see that totals 14,700. 815. So it's 35,000.
There's another paragraph that I guess does ask for 35,700, but I'm not entirely sure how he justifies getting to that large amount.
Okay, so I'm sorry to muddy the waters, but to me it's just not clear what the appeal specifically is for, whether we've captured what the appeal is.
I'm not sure how to remedy that.
Then I will rest my case.
We could amend the motion or vote on the motion. Does anybody else have anything to say on this? Because I'm going to call the question on this motion, and we'll move forward. Nobody else has anything. Let's vote, please.
Commissioner Bogdan?
Oh, you're not going to go to samplers?
Commissioner Bogdan?
Oh, yes.
Commissioner Pitts?
Yes.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Dowdle?
Yes.
Commissioner Lucas?
No.
There are 5 yes votes, motion passes.
Okay, so that is Mr. Robbins' appeal. That was Mr. Robbins' appeal, yeah?
Oh, yeah, there's the other one.
Now we need a motion on the landlord's appeal, please.
It's a motion on 503, case 503-245-20 on the owner's appeal. I move that we uphold the decision of the general manager and deny the appeal because the request for relocation was prior to the closing of the violations case.
Is there a second?
I'll second.
There's a motion and a second. Any discussion? Okay, call question. Whenever you have it. Whenever you're done. No. Oh, yeah, it's yours.
Commissioner Bogdan?
No.
Commissioner Pitts?
Yes.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Dowdle?
Yes.
Commissioner Lucas?
Yes.
There are 5 yes votes, motion passes.
Okay, thanks for all the parties for appearing and being heard. To the extent you have any questions before you leave about next steps, we have staff here to help you out. Don't leave the building without order. I think here. Okay, thank you, Ms. Diaz. We're gonna take a break for 10 minutes. It's 1:40. Be back here at 1:50. That's quite a long break, so please, please, please be back on time. We're off the record.
Okay, we are back on the record.
And it's 1:52. I think we have everybody, just for the record. The next case is 2A. Yeah, did we ever have anybody show up that needs a translator?
No.
All right, let's do introductions. Hello.
My name is Jocelyn Lopez.
Ms. Lopez.
I'm the property supervisor for the subject property 5851 Knoxville Boulevard.
And is somebody else here on this case? I have Alex.
Well, it's the interpreter. He signed in, assuming.
Oh, I see it. So we have no interpreter needed for this case. Thank you for hearing that.
I'm Barry Cradoff. I'm a senior inspector with Code Enforcement.
And Matthew Holen with the Housing and Community Investment Department.
All right, let's have the initial report for the case. Swear in, please. Raise your right hand if you're able. If you're intending to testify. Do you promise or affirm the testimony you're about to give is the truth and nothing but the truth, so help you?
Yes.
Thank you very much. All right, now the initial report.
Thank you. This is Matthew Holen for the department. This case is an appeal of a general manager's decision to affirm a department decision to accept the subject property into the rent escrow account program. The appellant states that repairs were made at the property, but the property supervisor was unable to provide evidence due to traffic. The supervisor tried to let the department know she would be there late, but no one answered the phone. The background of the case is as follows. On June 13th, 2017, a complaint inspection was conducted at the subject property. Violations were observed, and a notice and order to comply was issued on June 14th, listing 16 violations. A reinspection on July 27th found 6 violations, and on August 31st, 2017, the department issued a notice of general manager's hearing and notice of acceptance into Reeve. The hearing was held on November 1st, 2017, and on November 17th, a decision was issued affirming placement into Reeve. A summary of the hearing is as follows. Senior Inspector Barry Cradoff appeared at the hearing and provided testimony. He said there were 6 violations as of the last inspection. He said there was a fire door violation in the common area and maintenance, electrical, and smoke detector violations in unit number 109. No owner or owner representative appeared at the hearing. Tenants from units 109 and 205 appeared. They said that some violations have been corrected, but that many still remain. On October 27, 2017, a decision was issued affirming the department's decision to accept the building into REAP and the corresponding rent reduction. That concludes the staff report.
Okay, will the appellant and any witnesses for the appellant please present the reasons supporting your appeal for this case? You have 5 minutes, including rebuttal time, whenever you're ready.
Okay, so for the original inspection date, I have supporting documents that we did repair everything that was in the initial inspection report. The tenant, she signed off on a service request stating that all the repairs were done. I have pictures of providing that the door was fixed with the fire door for the common area. It was a hinge that was not working properly, and that's pretty much about it.
Okay, thank you. Let's keep your time for rebuttal. I'll come back to you at the end. Mr. Holen and Mr. Cradoff, you have 5 minutes.
Yeah, Senior Inspector Cradoff, I'll go first. At the time of the initial notice, there were 16 violations cited. At the reinspection that occurred on July 27th, the owner was able to get the number of violations down to 6. But the 6 violations that existed Looks like 5 of them were within the unit, and the one was a common area violation. There's been no call for inspection since the general manager's hearing on November the 1st, so the 6 violations are still unresolved. The owners may have affected those repairs, but there's no evidence that I can point to in way of the case manager's inspection to verify compliance. So as it stands today, we're still open with 6 unresolved violations. A number of them were high severity, smoke detector, the receptacle in the kitchen area, and the fire doors that would affect all the units because of the common area violation. And that's all I have.
Yeah, no, not much else for me. I think without any owner appearing at the hearing, obviously I understand that traffic can be bad and it can be hard to attend a hearing, but there was no evidence that the violations were corrected submitted at the hearing. There was evidence from tenants that there were still issues at the time of the hearing, I guess I don't see any error or abuse of discretion here. I understood the owner said that there's a tenant statement that violations have been corrected, but it's that's really not sufficient for the department. There needs to be an inspector at the property verifying corrections. A tenant acknowledging corrections is not enough for us to consider the matter resolved. That's all from me.
Thank you. Are there any third parties that wish to provide relevant testimony on this matter? Nobody's raising their hand, and nobody else has signed in, so I'm going to come back to you, Ms. Lopez, for rebuttal. You had almost 4.5 minutes left on your 5 minutes, so the floor is yours.
I would just like to say that as far as the re-inspection, I did try to reach out to I don't remember the inspector's name to see if there was a re-inspection, but because it was already pushed forward to the general hearing, he said that it was a different person that was going to come out, or I should contact, but I don't have that person's contact information. So I was here requesting if there was a way where I could do a final inspection so that the city can see that all repairs have been made.
Is that it? Can you stretch it out a little bit while
he's chewing?
He's chewing.
I'm just kidding. I'm kidding.
I'm
kidding.
A good
Okay.
thing to
Does
do is
anyone
make
have
this
any?
meeting go longer.
Does anyone have any questions of the parties or points to make? We do have new evidence.
Yes, okay, so I'm looking at that. Is that the 2A manager? Is that it?
Yeah,
Okay.
that's.
It's a document submitted by the manager. It's 7-page report. Appears to be. It's entitled Resident Ledger, and it's
And it's.
list of units and what they owe and what they paid.
Yeah, that's for the.
And then several pages of documents that include receipts and photos that are, I'm assuming, purported to show compliance with the.
And this was not shown at the general manager's hearing?
No, I didn't make it.
Oh, you were, this was the one you missed?
Yes.
Because of traffic, okay.
Do we have a motion on the new evidence, or we can take it up after questions?
I think we should accept it. I make a motion, we accept it.
There's-
Evidence?
Is there a second?
that.
Any discussion? I'm gonna vote no on it because I think that it is evidence submitted to show compliance after the fact. Am I wrong?
I agree with Sam.
Let's vote. If anybody has anything. All right, nobody has anything.
Commissioner Brogdon?
Yes.
Commissioner Pitts?
No.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Doggle?
No.
Commissioner Lucas?
No.
Alright. There are 3 no votes. Motion does not pass.
Even though it's 50-50?
That's the reason why it doesn't pass. Because it's 50-50.
Has to be a,
One more.
Does anyone want to put forth a different motion?
I can accept it, I'm okay
Yeah.
with it, I tend to vote yes to accept everything into evidence, because it doesn't really matter, the facts, it doesn't really change the facts of the case, so, I tend to vote, but I don't think it changes the facts of the case, so I'm okay with no also.
Okay, let's have another motion. I think Commissioner Paul has.
I just wanted to say that there are two things for me about this. One is sort of good faith because of the situation of this not coming in previously, but also that we vote on it before we know what it is. I mean, we should accept it before we know how it impacts our decision, right?
I'm not sure. Like,
Well, not necessarily,
give a
because-
benefit of a doubt and accept it, and then see how it affects.
Because-
Right, so
It
instead
either
of saying I
does
don't
go
accept
along
it
with the law or it
because it
doesn't.
doesn't prove anything, we would say, I must be
Or that's the one.
No, I tend to think that way too, same as Commissioner Paul. But in this case, I think what I would want to be looking for is a report from the inspectors that say that there's been progress made as opposed to receipts or invoices.
But you're responding to the content of the, but I think that the truth is, this is stuff that, evidence that you put in now is supposed to be something that if, that wasn't available at the general manager's hearing, that would have changed things.
Could not be produced without.
right.
But there's some of these things are after the date of the general manager's hearing, right? So.
Which in and of itself is not dispositive. It doesn't mean, just because it's after doesn't mean it can't be admitted. Because there's I'll read the standard.
Okay, that's a good idea. Read that.
Yeah. Is the appeals board shall not consider any evidence not presented at the general manager's hearing unless it is newly discovered evidence which could not, with due diligence, have been discovered and produced at the general manager's hearing.
Oh.
So there's an unless clause. Like if there's still,
This
it
for
can be
sure
produced
could be-
after the general manager's hearing. There has to be a good reason why it wasn't produced.
And the reason would have been that the person didn't attend, except for the date is today.
And I think what an argument could be is that if you find that there's a good reason why the appellant couldn't make the meeting to present the evidence, that's a good enough reason to accept it. Right. We also have our review standard, which says the appeals board may modify, but no, that's not what I want to read. The appeals board shall not do something. I keep thinking I see it, and then it goes away.
Well, it's good for us to always review this.
It's fine, it's
Yeah.
good to talk about it. Perhaps if Commissioner Stoller wants to change her vote, she should do that.
Well, we need a new motion.
Although the
No,
motion
my
didn't pass,
vote,
so.
This is what I wanted to read.
We don't need a new motion, let's just move on, Sam.
Well, the previous motion failed. We need a new motion. And it's the exact same motion?
Oh, really?
Yeah.
Oh, we have to have a motion on this, even though it failed.
I'll make the
Wait a
motion
minute,
to
thank you.
deny the evidence submitted today. Is that what you're looking for?
Yeah, it has to be dispositive one way or another. We deny it or we approve it.
Oh, so it not passing doesn't count as a resolution to the question?
I would rather us be clear about it.
Okay.
And I think there's enough.
Commissioner Hidalgo,
Yeah,
go for it.
So I'll make the motion to deny evidence submitted by the appellant on item 2A, which is case number CCRIS 626684.
There's a motion. Is there a second? I will second it.
Thank you.
And before we vote and in our discussion, I found that what I was looking for. compliance with orders to comply subsequent to the general manager's hearing shall not be considered. That's what I was going for. Okay, any more discussion on the motion? No?
Commissioner Brogdon,
No.
Commissioner Pitts,
Yep.
Commissioner Paul,
No.
Commissioner Stollers,
Yes.
Commissioner Doggle,
Yes.
Commissioner Lucas.
Yes.
There are 4 yes votes, motion passes.
Questions of the parties, that's where we are now. And comments on the cases, on the case. Comments, questions, concerns.
I mean, to me, this is pretty cut and dry. If the repairs have been made, the building will come out of Reeve quickly, once you get your new inspection, which you can talk to them today. But we can't decide based on pictures and testimony from a tenant that you've complied, and even if we did, that wouldn't do much because an inspector still has to come out and sign off on it before anything can happen.
Can you make that a motion?
Yes. I move that we deny the appeal for case number CCRIS 626684 at 6851 North Sepulveda Boulevard in 945, because there was no error of law or fact or abuse of discretion on the part of the general manager.
I second it.
Any discussion? None, let's vote, please.
Commissioner Brogdon,
Yes.
Commissioner Pitts,
Yep.
Commissioner Paul,
Yes.
Commissioner Stollers,
Yes.
Commissioner Doggle,
Yes.
Commissioner Lucas.
Yes.
There are 6 yes votes, motion passes.
Thanks, Ms. Lopez, for appearing. And staff is here, they can either get you an appointment or tell you how to get an appointment to get that final inspection done. So I think it sounds like you're ready for it.
Thanks for getting those repairs done.
And we're on 815 North, I'm sorry, 815 New Hampshire Avenue. That's case number 600723. If you're here on that, come on up, please.
Well, considering it, but not necessarily deciding one way or the other. based
Right,
on it,
yeah.
Um, That's kind of where I am usually. That's where I usually fall, I think, is like there's a lot of
Better to accept.
better to accept than not. But
Right.
sometimes to me, it seems
So
really
clear.
clear what it's.
It's not following the.
Like they say it's here's I fixed it, see, and that's the clearest to me. That's why I don't. I mean, I understand there's stuff like that. That's. But I have since May's visit kind of erred on the side of admitting.
I have too.
I think we all have. Because I don't think any of us love these long discussions.
God,
And we don't benefit
Oh, we
from
get-
that, but on the other hand, it's clearly outside of what it should be, so.
Right. I know. I know. All right. Thank you. We've had time to settle ourselves. Mr. D'Amico.
Yes.
Hi. Let's have you introduce yourself for the record, and we'll get you both sworn in.
Nicholas D'Amico, I'm here on behalf of the landlord and appellant, Central American Relief Foundation.
Okay. Thank you. Oh, and you are a member of California Bar.
Yes, I am.
So we don't need
Yeah,
to swear you in. Okay.
Yes.
Mr. Harrison.
Yeah, Stephen Harrison, Senior Inspector, representing Code Enforcement.
And we still have with us.
Matthew Holland with the department. Thank you.
Thank you. All right, Mr. Harrison, please raise your hand. Right hand if you're able. Is the testimony you're about to give today the truth and nothing but the truth, so help you?
Yes.
Thank you very much. Let's have a neutral report for this case, please.
Yes, thank you. This is Matthew Holland for the department. This case is an appeal of a general manager's decision affirming the department's decision to accept the subject property into the rent escrow account program. The owner states that a continuance should have been granted in order to complete the ongoing repairs. The background of the case is as follows. An initial SCEP inspection was conducted on December 23rd, 2016. Violations were observed, and a notice in order to comply was issued on January 11th, 2017, listing approximately 54 violations. On February 21st, a re-inspection was conducted. Some violations were corrected, but new violations were also found. An updated notice in order to comply was issued on February 22nd, now listing 52 violations. A re-inspection on April 10th found 20 violations, and another re-inspection on July 13th found 19 violations. On September 22nd, 2017, the department issued a notice of general manager's hearing and notice of acceptance into Reeve. That hearing was held on November 6th, and on November 16th, a decision was issued affirming placement into Reeve. At the hearing, Senior Inspector Stephen Harrison appeared and provided testimony. He said that there were 19 violations as of the last inspection. He said they included unapproved use, an unapproved unit, illegal construction, unapproved electrical work, weather protection, unapproved plumbing, sanitation, ventilation, and various maintenance issues. The attorney for the owner, Nicholas D'Amico, appeared at the hearing. He said they have made additional progress to correct the violations since the last re-inspection and submitted invoices and other documents to show what they have corrected. He said they were requesting a 60-day extension of time to finalize the correction of the violations. William Bella appeared on behalf of his mother, the prior CFO for the owner, who is now deceased. He said he is speaking on behalf of tenants in Units 1 and 3. He said there is an ongoing lawsuit regarding the ownership of the property. He said the current owner is not making corrections at the property and that violations continue to exist in Units 1 and 3. He said that a continuance should not be granted and that he believes the owner is just trying to extend time so that he can sell the property. Charles Janelle appeared on behalf of the unit and tenant 817.5, but did not provide testimony. On November 16, 2017, the hearing officer issued a decision affirming acceptance into Reeve and the corresponding rent reduction. That concludes the staff report.
Okay. Will the appellant please present the reasons supporting your appeal for this case? You have 5 minutes whenever you're ready, including rebuttal time, so keep a couple minutes back to yourself, I would say, so we can come back to you after you hear from the department.
Thank you.
Whenever.
So just to get right to it, our primary reason for the appeal here is that my clients believe that the individual that appeared during the general manager's hearing, William Bella, claiming to represent the tenants, was not actually a competent witness. He admitted during those proceedings on November 6th that he had no personal knowledge of the condition of the units or the property in general at any point after the September 22nd order to place the property into Reeve. And during that hearing, we had submitted evidence of repairs to those same units. So in essence, the gist of the argument is that legally under California Evidence Code, and I'm aware that the Evidence Code isn't a binding authority in these proceedings. However, it's very persuasive, and Section 702A provides in pertinent part that the testimony of a witness concerning a particular matter is inadmissible unless he has personal knowledge of that matter. And I would also submit that, as a matter of fundamental fairness for an evidentiary hearing, that this honorable commission consider that it would create prejudice to an interested party if incompetent witnesses were allowed to testify before the general manager. And I'd like to reserve some time for rebuttal.
Okay, we'll come back to you. Department, what say you? You have 5 minutes.
I'll start and talk a little bit about the appeal. This is Matthew Holland for the department. I think it's just important to I guess say that this is not a trial. It's an administrative hearing. It's a public hearing. The department does not disallow anyone from appearing at one of our public hearings and providing testimony. It is open to the public, and anyone can comment and speak on the issues. If they speak in a way that is either irrelevant or distracting, the hearing officer certainly can and will cut that person off. And I think in this case, did so when the person who appeared spoke kind of off the topic of the case. But he's not a witness. Nobody called him to speak on their behalf. In the traditional sense of a witness, he was a participant who voluntarily came to the hearing on his own. I also don't think that his testimony really affected the hearing officer's decision. The violations in this case were cited last year in 2016. Many multiple extensions were given by the inspectors during the inspection process, and the violations still weren't corrected. And there were quite a few of them, 19 violations still outstanding. So I think the hearing officer's decision was, of course I can't get in the mind of the hearing officer, but I think the decision was not a difficult one given that there were still violations. I understand the owner's argument that they were making efforts to correct and were making progress towards correction, and I don't dispute that. I believe him, but there's no requirement to grant a continuance when there's progress being made at all, let alone when time has already been given in excess of 9 months to correct the violations at the time of the hearing. I'll turn it over to Inspector Harrison to talk a little bit more about the violations and anything else that I missed.
Just make a few comments. From my review of the case, concern for code enforcement is to know that and be certain that the ownership of the property is noticed, that an inspection is going to take place. In this case, this was a systematic code enforcement program inspection case, normally noticed 30 days prior to any inspection. That's what took place here. The ownership's representatives were present at the initial inspection and were also present at reinspection during this case. There were several representatives in the process. I'll state that we met with at least 3 separate individuals on site for re-inspections, and those re-inspections did not produce a full compliance in this case. There were 62 code violations cited initially. It was reduced to the 19 code violations that arrived at the general manager's hearing. Those violations continue to exist. There are permit issues involved. There are use issues involved. The compliance stalled at a point in time, and there has been no effort or contact that we can see in our record to request a reinspection to address any further compliance. I'm sorry. There was a contact very recently. The date was December 18th.
I believe there was an inspection this morning.
December 18th, and on that date, representatives did and have requested that a reinspection be take place, and that was scheduled for today.
Okay, at this time, are there any third parties present who wish to present testimony on this matter? There's nobody raising their hand, and there's nobody signed in, so I'm going to come back to you, Mr. D'Amico. You had a good 4 minutes left.
I do have a question. Do we know what the results were of today's inspection?
All questions shall be asked of the appeals board.
We don't.
And I am under the I am informed that it happened today, but I don't know the results of that. Mr. Holland,
We can bring it up and look if you give us a minute.
Don't use your time on that though, because I'm not sure that's going to happen.
My understanding is there were still 13 remaining violations as of today's inspection. Is what I'm.
And I'll just, while we're pulling it up, and I hope this won't take any time, but just as a reminder to everyone, that even if the violations were corrected today, we're only looking at what the general manager had in front of him or her on the day of the general manager's hearing. So we will congratulate you heartily, but it won't affect
Yeah, no, I understand. I do have a statement from the president of the foundation.
You have time left.
To read it. So here we go. It's Mr. Hugo Merida, the president of Central American Relief Foundation. He has this to say: we are a California nonprofit public corporation. Our primary mission is to provide shelter, assistance, and care to abused and disadvantaged families. This organization was recently overwhelmed by the untimely passing of a key board member who was responsible for management of the foundation's real estate, as well as the departure of several other key personnel. The foundation sincerely apologizes for its oversights and inconveniencing this department, and we continue to make every effort To remedy the remaining violations, we are humbly requesting for a continuance and extension of time to allow us to complete the corrective measures at the property. And I don't have anything further to add. I don't have any new information. I'm sorry, so rather than try to guess.
Okay, thank you. Were are we questions or comments of the parties? I'll say that whether or not Mr. Is it Vela's testimony was, there's no evidence to show that his testimony was given any undue weight, and I think there's plenty of evidence that the hearing officer could rely on to find that violations existed at the time of the hearing. If significant enough progress is made, sometimes we'll see a hearing officer give a certain amount of time as a continuance, but the regulations greatly defer to the hearing officer, letting the hearing officer decide when it is due and not. Sometimes we'll overturn that decision not to give continuances if we see overwhelming evidence of movement, but I don't see that here. I see movement, good movement, but not so much to make me to have me overturn the hearing officer's decision and say it was just an abuse of discretion not to give more time. Those are my initial thoughts. Does anybody have questions of Mr. D'Amico or of the department or anything they want to say?
I agree with the chair, and I would also want to mention that we have a brief
Oh, good.
Yeah.
But this is one of those
But
easy ones.
a brief just becomes part of the record, doesn't it?
That's why it's easy. So let us, where did it go? Have a motion on Appellant's brief.
I'd like to move that we accept the item 2D landlord appellant's brief as evidence.
Okay.
I'll second that.
And Mr. Chairperson, if I could point out, that's the same briefs we filed with.
That's in here as well?
Yeah, it's the
Oh, so
same.
we don't
There's
even have
no
to-
different, yeah, I didn't want the commission to waste this time, I'm sorry.
Okay, I'm
It's the
thinking
same
it
brief.
looks familiar.
Well, we appreciate that.
Thank you.
So let's.
I retract my
if you
motion.
retract your motion, do you?
Yeah.
It's not new evidence.
Sorry for not saying that earlier.
No, that's
I'd like to move that we deny the appeal on case number 600723 at the address of 815 South New Hampshire Street Avenue in Los Angeles, as there's no evidence that the general manager erred in his or her discretion, and there's no error of law.
I'll second that.
Any further discussion? Nobody has anything?
I just wanted to thank the agent for the landlord and pass on our gratitude for housing people who may not otherwise be able to find affordable housing. And I'm sorry that this series of events happened that made the building fall into disrepair. But it sounds like you guys are really close to correcting these violations, at which point the building will come out really quickly and everything will be back to normal. I just wanted to say thank you for correcting violations. Please pass on our best wishes to the board, and
Thank
we
you.
express our sympathies for the passing of your board member.
Appreciate that.
All right, let's vote, please.
Commissioner Barkley?
Yes.
Commissioner Pitts?
Yep.
Commissioner Paul?
Yes.
Commissioner Stoller?
Yes.
Commissioner Darrow?
Yes.
Commissioner Rodriguez?
Yes.
There are 6 yes votes, motion passes.
Thank you, Mr. D'Amico.
Thank you.
Is that it? Is that the case?
Merry Christmas.
Yes, that's everyone. Okay, that's it. We're adjourned then.